Hello, 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 everyone. Hello, everyone. Welcome. This is a recorded session, but as you are coming in, please use the chat and introduce yourselves. When you introduce yourself, please feel free to offer your name, your agency, and where you're calling in from today. It is great to see people here from all over the country. If you would like to activate the closed captioning, you can do so by clicking the Show Captions button on the bottom of your screen. And as we get started and into our conversation today, please feel free to comment along the way in the chat or ask questions by using the Q&A feature also located at the bottom of your screen. We'll keep an eye on those. We'll keep an eye on those questions, and we may respond directly into the Q&A feature, or we'll save them to be raised at the end, depending on where they best fit in. And you can also upvote your favorite questions to make sure that they get asked as a part of our conversation today. And so while you all are introducing yourselves in the chat, let me introduce myself. My name is Kimberly Richards, and I am with Justice System Partners, and we are hosting today's Pet Network webinar about taking an equity lens to mandatory noncompliance reporting to the court. And so to kick us off, I would just like to give a little backstory about what the Pet Network is. So launched by the MacArthur Foundation in 2015, the Safety and Justice Challenge, or the SJC, aims to change the way America thinks about and uses jails. The foundation has invested in over 40 local criminal justice systems across the country that are working to improve public safety, eliminate racial and ethnic disparities, promote stronger and healthier communities, as well as reduce the financial costs associated with incarceration. And we all know, right? Jails have become warehouses for people who are struggling financially, people who may lack housing, or face challenges with mental illness or addiction. And so they starkly reflect America's long history of racism. We know jails are misused, and we know they're overused in ways that are damaging to families, devastate communities, and ultimately lead to more crime. And so the SJC has invested in locally developed equity-based solutions that take a balanced approach to protecting public safety. The goal is to support policies and practices that will safely reduce jail populations by 50% across all safety and justice challenge jurisdictions by 2025. So, as a part of the SJC, we have the Pretrial Equity and Transformation Network, or the PET Network, which is really an opportunity for peer learning. And part of this peer learning network is our webinar series. And so the goal of the network and the webinar series is to elevate SJC sites who are engaging in meaningful front-end transformation work and provide opportunities for other sites, other jurisdictions to learn from this work. And so this series brings together technical experts, people with lived experience, and practitioners to discuss new and promising programs and practices and share some lessons learned. And so today, really what we're going to do is spend some time unpacking the evidence behind mandatory noncompliance reporting. And then from there, we have a beautiful set of panelists. We're really excited for our discussion. We're going to just spend some time discussing with our panelists on what mandatory noncompliance reporting looks like in their sites. And so as a reminder, there is that Q&A feature where you can submit questions. Again, we encourage you to upvote questions. We encourage you to hop into the chat and participate in the conversation. Your experience matters, your perspective matters. So please feel free to, have the conversation along with us. And with that, I'm going to turn it over to my colleague, Shannon Magnuson from Justice System Partners, and she's going to unpack the evidence around mandatory noncompliance reporting. Shannon, over to you.
Thanks so much, Kimberly. Really appreciate that. I'm going to set this up here. Appreciate your patience here while I set this up. There we go. Awesome. I feel like I'm sharing my screen correctly now. Okay, I see a yes from some folks, so I appreciate that. I'm going to spend some time, talking a little bit more about the evidence about noncompliance and what that looks like. And I so appreciate Kimberly kind of setting the groundwork for us of, what the goal of the MacArthur Foundation Safety and Justice Challenges really is about reducing the use and over-reliance of jails and rethinking about how we use them. And one of the primary ways we are currently using jails is to certainly detain folks pre-trial, and also to hold people when they are non-compliant if they are released. And so we're going to spend some time today talking about what we mean by non-compliance, first and foremost, how we even get to non-compliance, so we understand the grounding there, and talking about kind of the consequences of non-compliance. And then how do we do this all better? Because we know as pretrial agencies, we're responsible for telling the court what is happening with folks that are being released. Well, I'm going to ramble on for about 15 minutes or so here. I think there's a couple bottom lines that if you were to hear nothing at all, here's some things that you absolutely have to take away from the conversation, right? Which is returning individuals to jail for technical violations, and we'll talk about what those are and what we mean by that. But technical violations to pretrial release is counterproductive to the goals of using jails less often. We'll talk about how technical violations are not necessarily illegal outside of the context of pretrial. And so thinking a little bit more about, do we want to be using jails for something like this? The second bottom line is that keeping individuals in the community following non-compliance to technical conditions is going to require something different of us potentially. And that's going to require contextualizing and humanizing the non-compliance experience. This is like a really, really small microprocess in a very large and complex pretrial system. But it's this really important microprocess that is really important for making sure people stay in the community, and that way we're not using jails too often or over-relying on them. So let's take a step back and think about what are the types of pretrial release that exist. Certainly, we know that folks get arrested and there's a jail booking. Some folks experience an immediate release, and that's not really entirely what we're talking about today, but we're going to talk about that. When folks show up to a release hearing because they're detained, they're going to remain detained. They could remain detained. They could experience pretrial release. They could, in that pretrial release itself, they could experience an ROR, so a release on reconnaissance. They could experience money bail. They could experience pretrial supervision, or they could experience money bail plus pretrial supervision. We understand that across jurisdictions, the ways in which jurisdictions use each of these release strategies is different. Some places don't use money bail anymore. But what we're talking about really is this group of people right here. People who experience a release to pretrial supervision in some capacity. When people are released to pretrial supervision, we understand that they have general release conditions or conditions of release. Those general release conditions typically look like don't commit new crimes, don't contact a victim or go to the property where the crime occurred as necessary, of course. Generally stay in the county or state, keep an updated address, and attend court hearings as scheduled. Generally speaking, regardless of the type of release somebody is experiencing, these are about the general conditions of release. We also know that there can be additional release conditions. Those could look like report to pretrial supervision as instructed. All of the pretrial supervision agencies that exist operate differently. There's phone, there's in person, there's only phone, there's only in person. It could be virtual. It could look like a lot of different things, and we understand that. The other release conditions could also be submitting to a substance use evaluation, or submitting to UA testing, or adhering to SCRAM monitoring, or electronic monitoring, or GPS monitoring. Again, the extent to which your agencies use one or all of these is certainly varied, and we recognize that. There's currently actually no research about how many conditions people experience on pretrial release. We'll hear from three really spectacular pretrial directors later. And in their jurisdictions, they might have on average 3 or 4 conditions. The research is unclear about the standard number of conditions of release people experience. But what we know about release and compliance to these conditions is that a vast majority of individuals remain compliant with pretrial supervision release. That's great news. People are doing what they need to be doing, and we love that for them. It makes our jobs easier. There is a smaller subset, though, of folks that are not compliant. And what we're talking about today, then, are people that are truly on pretrial supervision and then who are not compliant generally with their pretrial supervision release conditions. And when folks are not compliant with their pretrial release conditions, they can return to jail, right? We know that to be true, and that's the grounding of why we're here today. We also know that when folks are non-compliant, what courts typically and can do is maybe increase the level of restrictiveness. So increase reporting, increase testing frequency, increase the type of monitoring that is happening. We know that non-compliance can create additional surveillance. It also could just be non-compliance ends in a continuation of the pretrial release conditions and the ways things have always been operating anyway, regardless of the non-compliance. And I think what we want to spend time today, and I think the pretrial directors will talk to us about, is how do we do this? In the face of non-compliance, how do we make sure that people just stay on non-compliant, stay on pretrial supervision, and how do we work with them to maintain that kind of status and stay in their communities? But when we're thinking about the types of non-compliance that happens, I think we first have to think about the types of conditions. And so we've kind of parsed the conditions out in two main ways. There's kind of these law-related conditions that people have to abide by, right? Don't commit new crimes, don't have contact with victims or at the property where the alleged crime occurred. And then these more technical related conditions. The more technical related conditions are rules that we made up, quite frankly. There's actually not a lot of research that any one of these, particularly submitting to a substance use evaluation, submitting to UA testing, or adhering to some kind of SCRAM, EM, or GPS monitoring, evidence right now does not tell us that those conditions actually increase court attendance. So there's a bit of a misalignment about what we're asking people to do and the outcomes that we can actually expect from them. But what is true about all of these conditions is that they're technical by nature. They're not illegal outside of the context of pretrial release. And when we're talking about noncompliance today, what we're really talking about is the noncompliance to these types of conditions. And what the research, JSP and Ideas 42 and other emerging research is talking about now is really the reasons why people are non-compliant with the conditions of pretrial release. That looks like work obligations. It looks like not being able to afford fee structures or payments for testing or monitoring devices, not having personal transportation to get someplace, not being able to afford ride share opportunities, kind of being out of favors or out of social capital with your friends to get to more and more appointments as they go on. Childcare and other caregiving responsibilities, non-compliance with medicine that can interact, decision making and the ability, executive functioning and the ability to get to where we need, other healthcare needs and obligations that we have, particularly on the other side of COVID, and just general housing instability. We know these are some of the reasons why people are non-compliant with these technical conditions. But what's underexplored is all the ways that there are also system barriers to non-compliance, right? The idea that courts operate during typical work business hours. That's a system issue that may actually be complicating how well people can comply with some of the rules. Certainly that some courts cannot afford or assume financial responsibility for fee structures of people. That's a systems issue. A lack of suitable or really accessible public transportation can be a challenge. A lack of affordable childcare options or rules about if folks can attend pretrial appointments or courts with their children or other people that they give care to. And really that the idea that navigating and enrolling in government healthcare is incredibly challenging. And that might mean something for the ways in which I have to enroll in UA testing or get an evaluation or do other other conditions related to release. And what is true for folks is that emerging research is saying that these barriers are not one-off, that many of them can be co-occurring. And when they're especially co-occurring, or even if one is just happening, that each of them doesn't just affect one condition of release. it's understandable that it affects multiple conditions of release. And as a result, it may look like folks are non-compliant to all of release, when in reality, the situation is they have one individual barrier that happens to affect so many of those conditions. This is also true for system barriers, that system barriers are equally as prominent, and that one system barrier might actually affect multiple conditions of release. And what's really important as part of the story is that individual barriers and system barriers are reinforcing, co-occurring, and chaotic. And so it may look like there is chronic non-compliance and over time, but when reality is that these may be conditions for some people that were always unrealistic because of the individual barriers that they face and the system barriers that they face. What we know then is that when noncompliance happens, regardless of the type of noncompliance, we have to report that to the court, and pretrial agencies have a duty to do that. Of the 3 counties we'll hear from today, Allegheny, Kane, and Lucas, we know that reporting looks like in Allegheny, that it's kind of noncompliance is reported as needed. In Kane County, it happens, noncompliance reporting happens at every court date. And then in Lucas County, noncompliance reporting happens at every court date. That may be true. These systems may be true for your own agencies. They might also look different. In the counties that we're featuring today, what they report to the court, or the type of compliance that they report to the court, is both compliance and non-compliance, which is super exciting, which means that we're telling the court, hey, folks are struggling and folks are doing well. I think the amount of times we're able to tell the court folks are doing well is really important. What's really great about the agencies that we have featured today, which I think we'll hear more about, is that when folks are doing well, these counties actually have systems to advocate for folks that are navigating the system to make modifications. That's to reduce the restrictiveness of release. That might be to actually remove them from pretrial supervision altogether, really finding ways to get out of people's way when they're doing well. But when they're not doing well, there are different types of information that we want and should be thinking about, that we can and should be reporting. Some of those things really are about offering context to what noncompliance is, offering the idea that that noncompliance doesn't happen in a vacuum, that noncompliance can happen for lots of different reasons. And so as we're thinking about reporting noncompliance, and particularly mandatory noncompliance to the court, we have to be thinking more critically about the type of information we're presenting with that noncompliance. And one of the ways we're thinking about that is also reporting the rate of noncompliance compared to compliance. And so what that might mean is telling the court, people are compliant with most of their conditions, they're just struggling with this one. Or people are compliant with this one most of the time, they just struggled this one time, right? And then offering why that happened. And that really lends to this idea of describing noncompliance as either situational or chronic, and really giving evidence of that. So is this event or is this context of noncompliant really situational? Was there a one-off thing that was happening? I have to tell the court about this noncompliance, but truth be told, it's not happening all of the time. Or it is happening all the time, but here are the system barriers that are present for these folks that are not going away. And so to expect continued compliance to this condition may be challenging. I think it's okay that we offer that to the court. And I think the last thing we want to think about is contextualizing these challenges, or challenges that happen that are actually strengths. So when we see personal obligations competing with court obligations like work or school, it makes sense that we want to expect people to show up to pretrial, and certainly makes sense that we want people to show up to court. But they could be doing other things that actually increase their stability, that are in the way for them to get to court or to get to pretrial. And I think those are the things we want to tell court. Yes, there's non-compliance to these conditions, but the reason for that is actually really good. The reason for that is that they have strength-based things happening in their lives that we want to maintain. And how do we work around this? Ultimately, then, if the goal is to maintain the least restrictive pretrial release possible and to keep people in the community even after non-compliance, then that means we have to be thinking about this very specific microprocess, which is really about contextualizing and humanizing the non-compliance experience, understanding that this is not happening in a vacuum and that there's a lot happening for people. I think the way that we infuse fairness and equity and dignity into the process is to recognize that people are people and they're managing people like things. People are having human experiences. I think that part, sharing that with that court, the storytelling that goes into that is the ways in which we can elevate the type of work that we're doing with people to keep them in the community and reduce our reliance on jails. So after all of that, here's two big things, again, that are important to remember. Returning individuals to jail for these technical violations or non-compliance is counterproductive to using jails less often. And then if we're going to keep people in the community, even after non-compliance, we really need to be contextualizing and humanizing that experience. And if there was one more bottom line for good measure, I think it's the idea that advocating to remove conditions or move individuals to the least amount of supervision possible can actually help people stay in the community. And that feels counter to the role, perhaps, of pretrial. We want to provide support and surveillance to people to help them get there, when in reality, it's possible that we just need to take a step back and let them and get out of their way. And I think the ways in which we can create systems to do that is certainly going to enhance keeping people in the community, helping people navigate their cases successfully, and certainly reducing the reliance on jails. With that, I'll turn it back to Kimberly.
Awesome, awesome, awesome. Thank you so much, Shannon, for sharing that with us. I think it's really important context. And it really provides, right, the basis for understanding and legitimizing the reasons why people struggle sometimes to make it to court, and how we can really be considerate of ways to support them a little bit better in that regard. And so with that, we are now going to transition to our panel discussion. But first, I would like to introduce our panelists to you, and their full bios will be shared in the chat for your reference. But starting with Ms. LaTanya Hill. LaTanya Hill is the director of Kane County Court Services in Illinois, and she has a deep professional background in both foster care and the criminal justice system for adults and youth. She brings valuable insights into the micro and macro drivers of problematic behavior. Additionally, she is a SAMHSA certified trainer for the curriculum to improve criminal justice system responses to trauma, and her contributions to policy and practice on the statewide level include being a contributing member of the Illinois Domestic Violence Pretrial Working Group, Illinois Supreme Court Pretrial Assessment Subcommittee, Illinois Supreme Court Committee on Juvenile Courts, Committee on Pretrial Education, Pretrial Officer Work Group, and the Illinois Judicial College Committee on Probation Education. So we are very excited to have LaTanya here with us today. Additionally, we also have Christopher Shanley. Chris Shanley is the director of Allegheny County Pretrial Services in Pennsylvania, where he oversees the comprehensive management and administration of the department's activities, including bail services, behavior assessment services, alcohol highway safety services, and ARD diversion services. His extensive experience in implementing pretrial services spans local and national jurisdictions. He is a former president of the Pennsylvania Pretrial Services Association and serves as a master trainer for the Pennsylvania DUI Association. And lastly, we have Michelle Butts. Michelle Butts is the director of Lucas County Regional Court Services in Ohio, which is comprised of pretrial services, electronic monitoring, and centralized drug testing. She has spent nearly 3 decades at Lucas County Court of Common Pleas, leading efforts in pretrial systems improvement and promoting the success of individuals who are pretrial. She has overseen the implementation of pretrial assessment tools and evidence-based practices, contributing significantly to advancements in pretrial bond supervision and electronic monitoring. Her expertise is recognized at the local, state, and national levels through her presentations and active participation in the criminal justice community. And so with that, I just want to welcome our panelists, Michelle, Christopher, LaTanya. Thank you so much for being here. We're really excited to dive into our conversation today and learn from your expertise in this field. And so really just to kick us off, Shannon gave a great kind of overview of what we know about in the pretrial reporting space, particularly as it pertains to mandatory non-compliance reporting. And so for each of you, just curious, what do you see as the role of your pretrial agency as it's related to helping individuals get to court? And so for this, I'll kick it over to Michelle first, and then we'll take it from there.
Thank you. Welcome, everyone. When we're talking about getting people to court specifically, what my agency does is, first and foremost, is we are there to assist people. Sometimes people don't know what their court dates are. We will look it up. We inform them. If it's a new hearing that was scheduled, we'll inform them, but always we are there to remind them not only of when their court date is, but where it is located, how to get there, how to even just traverse the court process. We talk to them about, do they have a plan of how they're going to get to court on the day of court? It's always good to know, have a plan in case something falls through, have a backup plan. Make sure they have a ride, and if they don't, we can offer bus passes to individuals.
Great, thank you for sharing that. Right, like there's really that level of communication, and what else I heard is not assuming that somebody knows exactly how it's supposed to go, but really ensuring that you've had that conversation with them. Thank you for sharing that. How about you, Latanya?
Much of the same. Our clerk system has a possibility where they can sign up their telephone number and they get automatic court date reminders. But even before our clerks set that up, maybe a year or so ago, we were already sending text reminders similar to your doctor's office, your dentist's office. And the clients had to opt into that because we do recognize that some clients still are paying for text messaging and things of that nature. So it wasn't mandatory that they had to, but if they opted into that program, they automatically get court date reminders a couple of days before their scheduled court dates. If they don't opt into that or they don't have a working telephone, we try to reach out to them via email, somebody else's phone, whatever way they tell us that we can get in contact with them. We try to get into contact with them to remind them of court. We do offer bus passes right now through our pretrial program for those that have issues with transportation. As most will know, that's starting to get very costly. So I might have to, have a reevaluation of some of that to a certain extent here coming up. But we do offer bus passes and try to navigate. Our court does some court dates via Zoom. So we are trying to let them know whether or not they have an in-person court date or a Zoom court date to just get them through that process.
Yeah, thank you for sharing. And yeah, there was something really interesting about what you mentioned regarding the automated court reminders, right? Like even thinking about the little nuances of, we don't want to make this mandatory because we're taking into consideration the expense it may cost for somebody else. As Shannon was mentioning, right? Those financial obligations are not something to gloss over. So I appreciate you calling that out. Chris, how about you?
So we're very similar to the two other jurisdictions, and we do a lot of the same things, except we don't give out bus passes. I wish we did, but unfortunately we don't right now. One of the things that we do is pre-trial is for those that are to report to our office in person, we have them report to our office the very next day at 10 o'clock. And if you have ever experienced someone who is new to the criminal justice system, the amount of paperwork that they're handed as they walk out the door of a jail is overwhelming. And the first thing our officers will do is say, okay, when's your next court date and where is it? And you just have this like blank look on their face that they don't know. And that's to be expected. So our supervision officers will sit down with them. They will sort through the 17 pages of paper, find the next court date, highlight the next court date, and we give them a blue supervision card that lists their next court date, the date, the location, our phone number if there's any issues. And if they have other pending cases that they're not on supervision, we also list those as well. Because we didn't think it's fair to tell them about the one case we supervise them on and forget about the other three. So we are kind of all incorporating of all of their court dates onto one blue card with our phone number. They can call us if they have any questions about what location they need to be at, what time they need to be at, questions about the public defender's office. So we try to give each person as much information about their next court date so they can make it there on time. And we also do the text reminders as well.
Awesome. Yeah, and I appreciate, and like you mentioned, similarly among the three of you, right, there really is that the elements of communication, the elements of really supporting people to understand what the expectations are. And even recognizing, right, that there may be additional court processes that they have to go to besides the one that they are with you for pretrial supervision. Chris, I'm curious, in your experience, how well are people navigating their pretrial release conditions? Are there certain ones that are maybe easier to be in compliance with, or even more difficult to be in compliance with?
I think the majority of people are very successful in the reporting either by phone or a person to our office. And I think it's a lot harder for someone who is ordered to have a drug and alcohol evaluation done or a mental health evaluation to be done, because that's a financial burden. And it's also a burden to a lot of people who don't know how to navigate a system. And we looked at this in Allegheny County probably about 7 or 8 years ago, and we did exit interviews. And we asked people specifically, what was the hardest thing to do while you were on pretrial? And a lot of people would say that just finding a place that would accept my insurance, or finding the time. I can't take off a day of work to go do a drug and alcohol evaluation. It's either take the day off of work and go do that, or take the day off of work and go to court. So, we're advocating for going to court. So it was an interesting perspective to look at our supervision through the eyes of the person who's on supervision. We can provide them with a list of 20 agencies that will do a drug and alcohol evaluation, but we were finding that people were not going to their initial court date because they couldn't take a day off to do a drug and alcohol evaluation. And they were afraid to go to court, and they were afraid to be returned back to jail because they haven't satisfied that bail condition. So it was a communication change with how our officers, our supervision staff would talk to people.
Yeah, and I think, it's really interesting, right? Like there's that gap between even, for your agency to provide, right, a list of places that someone could go for their testing. There's still that gap in between, right? Even providing that and someone being able to follow through with that for all the reasons that you've listed, and, echoing what Shannon's mentioned earlier about there are just conflicting priorities at times that are fully legitimate. And it's not necessarily that someone is trying to willfully or indignantly negate their court appearance, as much as they really are navigating a challenge, right? Do I make it to work, or do I go to court? I can only take off but so much. So do I take off to attend court, which is the highest priority of these conditions that I need to do, or do I take off to make it to testing and all of the implications that come with not being able to do that? So I really appreciate you kind of laying that out for us. And I'm curious. Yeah, and I'm curious for you, LaTanya, if you could share a little bit more about what reporting is looking like for you all in your agency, right? Like how often you're reporting and typically what's included in those.
It really depends on the level. We use the PSA here, so it depends on the level of pretrial supervision that the client was placed on at their first appearance court. We do a lot of reporting via phone, Zoom, things of that nature. If they are reporting in person, we try to have that occur on court dates so that they're not coming in. If they need to come in person, they're not coming in on another day, to kind of go back to some of the things that Chris was sharing, giving additional days. Talking about those difficult conditions, I think probably the most ones that we have to send, or we're sending non-compliance reports for, are they were released from first appearance court. And we ask them, especially during the week, to come straight over to our pretrial department, which is right next door to the sheriff's office where they would be released from, to do their initial intake. Just so, we want to go through, make sure they understand everything that's required of them, get telephone numbers, things of that nature. That's really where we get most people. They don't come next door, or it's a weekend. We never hear from them. They don't call and check in. We have no way of getting in contact with them. And I would say the other most difficult one is drug testing. we were seeing a huge increase in our judges ordering drug testing on a more frequent basis than what happened before no cash bail in Illinois. And just understanding the barriers that causes for people. We try to, work with them the best way that we can. We have 3 offices in my county. So we try to have them do their drug testing based upon whatever office is closest to them, but it's navigating transportation, work versus childcare and all of that. I'll never forget, we had one kid, she was charged as an adult, but was still in high school. And I think her drug testing was almost like 3 times a week. So trying to get her there on top of school, and court after court day, we were like, okay, can we please, and we'll put in our court report, we've tried this, we're trying to work through this. Can we look at reducing the frequency? Because it was really becoming almost impossible for her to meet that requirement. So I would say those are probably the most difficult. And then of course, your DV conditions, stayaways, you start to hear people not being compliant with that type of thing.
Yeah, I really appreciate you lifting that up. And yeah, of course, yeah, 3 drug tests a week on top of school, on top of anything else. Yeah, like that is admittedly, I think objectively hard to be in compliance with. And I'm curious for you, LaTanya, right? If an individual is maybe completely compliant, or at least mostly all compliant, and in what your agency may call good standing, is that also being communicated, right? Because I know you said, you're trying to keep that reporting as needed or as required. And so is there a way that you can also communicate when somebody is doing well, essentially?
So what we've been doing, and we even had a meeting with some of our judges about this issue, because it's also becoming a resource issue just for my officers as well. On our compliance reports, we'll put in bold, they've been complying with their drug tests all these times, they've been negative. Can the court please reconsider the frequency of drug testing? And even in those meetings, some of the judges have said, I saw your requests, but I'm just not going to do it based upon. But at least we are communicating that they've been compliant with this condition for months, potentially. Can we look at a reduction of that? We are starting to have conversations as well about starting to request a like step down and supervision level when someone has been compliant. That's something we have not implemented yet, but we are discussing that internally now as well.
Yeah. And, Michelle, I'm curious for you as well, right? If somebody is compliant or mostly all compliant, what does it look like for you in that regard to maybe communicate in some capacity that person is doing well?
At the time of every court hearing, we prepare docket information for the judges, for those individuals who are on supervision. We provide like a brief supervision summary for individuals. And so we'll say whether the person is compliant or non-compliant with all conditions, including general conditions. And if they're not compliant, we'll just notate what they may not be in compliance with. So for instance, if it's a reporting requirement, then we may just say need to report, with hopefully the judge recognizing that and then telling the client, go down to pretrial services after court and report. Or if they've not left a drug screen, reminding them that they have a urinalysis condition, things along those lines. But I mean, really the compliant piece is always present so the judge can see that. And, our defense counsel, they don't receive that information, but the defense counsel, I see it on the dockets routinely, are asking for bond modifications. And if the judge is equipped with that information, he or she may go ahead and approve that request.
Yeah, that's great to hear. Thank you for sharing. And Chris, I'd also like to get your insight on this, how it's working for Allegheny to, potentially communicate whether someone's doing well, whether they're mostly compliant, all compliant.
So at every bail hearing, and we have motions court every day, at every bail hearing we do, our judge and our court staff actually go over, is the person reporting is required or are they not? So we will address it. As far as compliance, we do not send anything to the court saying that they are compliant, but if the court asks, obviously we will send them notification. When we started pretrial back in 2007, we received an administrative order that allowed pretrial services to reduce the reporting requirements internally as we deemed appropriate. So we have the ability to take someone who is on pretrial supervision, who is ordered to report in person. Say that person reports once or twice, and then next thing you know, he or she gets a job and they're scheduled to work from 8 in the morning to 4 o'clock in the afternoon. We have the ability to reduce that supervision to allow that person to call us, which is, I think is tremendously helpful for our staff. We don't have to go back to the court. If we want to impose an additional condition or ask for additional sanctions, we absolutely have to have that as a hearing with defense counsel and the DA. But if we want to reduce the levels of supervision, we have the ability to do that internally.
Yeah, thank you for sharing that. And I think it's something kind of all three of you touched on in some capacity, is a form of communicating or trying to advocate for maybe modifications of conditions. And Michelle, you spoke to this a little bit, but just want to piggyback on something you had shared and see if can you offer an example really of when you might recommend removal of conditions? Really just to paint the picture for all of us here.
Sure. Like Chris said, we also employ graduated responses and incentive responses for people who are compliant with their supervision requirements. And that is something that, is a policy that we had drafted that our judges approved. Doesn't require any type of an order, but there are certain administrative things that we can employ within the agency, and also given individuals' circumstances, like Chris said, if somebody is employed someplace full-time and they can't report within our regular business hours, and you make other arrangements for them to report, via other means. And we can use Zoom virtual options. We can do texting. We can do phone calls, in addition to the in-person. But we do have the ability to step people down. Generally, all of our incentive responses are time-based, meaning that they generally have to have a sustained period of compliance before they can meet a milestone that will allow them to be stepped down in something. So we have like a phased approach to our substance use testing. And if they're testing negative, for a period of time, then we can step them down, and they can quickly get down to, only having to submit to substance use testing more infrequently, again, as long as those screens are negative. But in addition to that, after you've administered all of the administrative sanction or incentive responses, that is then when we can go to the court and ask that the court consider removing the supervision requirement and just releasing the person on their own recognizance with no further stipulations. But even above that, we have electronic monitoring as one of our supervision options for generally you would hope for higher risk individuals. And we have the ability that if somebody is compliant on electronic monitoring, or even if there are some significant barriers, that we can ask for removal of that condition. And we do that via a written report to the court.
Yeah, thank you so much for sharing, and really for all of you kind of, laying the groundwork for what reporting looks like in your agencies, and kind of sort of the impact that it's having for folks. And, we've talked about it in various ways, right? But we know that someone being ordered conditions also has a requirement for your agency to meet them or to accommodate their ability to be compliant with that. And so, we recognize general reporting as part of your role, but it does take some personal resources. And so I'm curious, and Latanya, you mentioned this a while ago, but right, have you worked with your court to kind of explore reducing reporting requirements, particularly because of resource issues, recognizing that it's not just the individual who has to show up for their UA testing or, has to show up to report in, but that also requires your staff to accommodate that or respond to that?
We've had conversations generally across the years, and we have ultimately had to reduce our supervision standards just because of resources. So I have 11 pretrial officers. But on average, I have about 3,500 people on pretrial supervision at any given time. So that's, running about 350-ish for each of my officers. So across the years, we've had to reduce how often we see people, how we see them, just for sheer mass of the number of people. Where we stand now, we just updated our reporting matrix. And I think it's really bringing us more in line to what the standards say anyway. The only ones we're really seeing in person are our level 3s, are our most highest. Everybody else is really court reminders, unless you've got a special condition for drug test or something like that. It's to do the intake, do the court reminders, and we're running the leads every time they go to court to make sure they're not picking up any new offenses. So we've done that just because of the sheer number of people that we supervise on any given day. In addition to that, since the implementation of the PFA, and I told you about the increase in drug testing, that's becoming a resource issue for us as well. So we have some people that are ordered just for random drug testing that we will do based upon, if we're seeing any concerns, if they've had any behavior indicators, things of that nature, we can do that off of our internal policies. But we were starting to see so many orders saying, 2 times a month, 3 times a month, 4 times a month, all the way up to 12 times a month. And just for those that had a specific frequency order, I had over 188 drug tests that I had to do just for the frequency, not including my randoms. So we had some conversations with the criminal judges, and I'm hoping to see a reduction in that. But it is becoming a resource issue and having us trying to reevaluate how do we meet the demand.
Yeah, absolutely. And I mean, right, 12 times a month for one person is a lot to manage, let alone, right, for multiple people, not including those randoms. And like you said, it's 11 supervision officers across 3,500 individuals roughly. That's a lot, So it's, a fair consideration about, how do we responsibly meet this requirement to match what somebody has been ordered for their pretrial release conditions. Similarly for you, Michelle, and you shared this before, but right, any conversations in regards to how to manage the impact on your agency's resources as a result of what somebody may be ordered?
Sure. It's not necessarily, I guess, an impact on personnel resources. I feel like we have enough officers to manage the individuals on supervision, but it's more of time management and focusing the time, especially on the people who need it the most. So it's having varying levels of supervision, varying reporting requirements based upon their supervision level, so that you are focusing more of that time and attention on individuals who are the least likely to succeed, who may need more wraparound services, who may need more direct conversations about getting to court, that they may have had contact with the additional contact with the criminal justice system and ended up back out on bond for those charges, and just having conversations with them about what they're doing in their free time, things along those lines. Where really just, if we're focusing our resources in the right places and allowing more flexibility with the individuals, meeting them where they are at, then we're just helping to ensure court appearance and community safety, which obviously those are our ultimate goals. You're on mute, Kimberly.
Thank you. I appreciate you bringing that in, right? That time management prioritization component, right, is not something to gloss over either. You have to be considerate of that. And that's an everyday consideration, it never really stops. And it's not like you get a nice moment of pause to kind of reassess before you hop right back in. It's ongoing. And so, right, really taking that into consideration. And, as we're talking about this and really, reflecting on what we're currently doing, but right, how do we take this equity lens? How do we infuse equitable practices in the way that we do reporting as it's mandatorily, required? For you, Chris, I'm curious, right? Taking this equity approach requires us to know if pretrial violations are occurring evenly across people. Is it happening equally by race, by gender identity, by the primary language that's spoken, by disability, age, or immigration status, right? Like, what are the types of demographic data that your agency collects, and what do you think may be important for your site to know about people that maybe you don't know right now?
So first of all, I'm glad I don't have LaTanya's UA budget. So we only drug test probably less than 50 people a year. But back to your question, and in all honesty, Kimberly and I had this conversation before we went live today, and I figured you would probably bring that up. So one of the things we do, we have a tremendous data analyst here in Allegheny County, and we have historically looked at failure to appear rates, and we've looked at FTA rates and new arrest rates, new violent arrest rates, and we've always categorized those by risk level. And Kimberly and I, before we went live today, I said to her, in talking to you and preparing for this panel, we have never really looked at failure to appear rates, new criminal activity rates through an equity lens. And I have already sent a Teams request to our data analysts and say, is this something that we can look at? Because we look at so many things when we apply our risk assessment to that person. Is not having a driver's license indicative of someone who's going to have a higher FTA rate? And looking at that through an equity lens, I would probably say it probably would. So even though I am on here as a speaker to talk about, what we do very well, this is something that, I think we are going to look at as we go forward.
Yeah, and I really, I'm glad you mentioned that, right? Because that's also what PET is for. This is a peer learning network. And so sometimes, right, and even as we got into this conversation for the JSP PET team, right, really digging into some of these questions and then stepping back and saying, actually, I'm not sure if I know about this. I'm not sure if I have all the data to answer this question. And it really is an opportunity, right? Like, it may be something we haven't had before, but allowing this to be an opportunity to be creative, to be innovative in a way that we can start to collect some of this data and really measure the impact of pretrial reporting, right? Like that's kind of what we want to see, is understanding what's happening for folks as a result of this process that, is baked into the CJ system. And so I appreciate you calling out that even just having these conversations can sometimes bring up or, shed light on an area that maybe we haven't delved deeper into, but is now an opportunity for us to really consider.
Mm-hmm.
And, yeah, go ahead.
We have a racial equity working group that looks at the pretrial stage, and we also have a racial equity working group that looks at the probation side as well in Allegheny County. So we are looking at it, but we've also kind of focused that lens as to who is still in jail and can't get out of jail. So we actually have probably a lot more talking points at the next meeting. Thanks, Kimberly.
No, for sure. And I mean, you bring up a good point. Yeah, maybe it's not baked into our system broadly, but right, there could be like a subset of folks that are taking a particular lens, and some of the practice that are happening in pretrial will filter into the work that they're doing. So, right, even if it's not pretrial actively seeking this, there's some space where someone is thinking about this or considering this or trying to learn more about it. Yeah. And, right, as we're thinking about taking an equity lens, this also means that we want to be mindful, we must reduce the opportunity for technical violations to send individuals back to jail during case processing. Shannon mentioned it earlier, right? But a lot of the technical conditions, if someone is not in compliance with that technical condition, it's not necessarily illegal, right? They just have a technical violation, but returning back to jail for something that is not illegal, puts us in a sticky situation. And so it's possible, right, that individuals may even be returning to jail for noncompliance with specific conditions, they may be more likely to receive a revocation of their pretrial release status for some conditions, maybe rather than for others. And so, Michelle, for you, I'm curious, maybe your agency does or does not, measure this outcome right now, but what data would you suggest your agency or any other agencies collect in the future to understand if individuals are receiving those violations to some conditions more than others, or, revocations because of some conditions more than others?
So I will preface and say that we have been collecting this data for years, but we have not necessarily analyzed the data. So, but we have been collecting the date of the violation, the reason or reasons for the violation, what we are recommending to the court happen with that individual. And we also record what the judicial decision is so that we can see, if there is any concurrence rate, or if, certain violations are, and it may just be one judge that a certain violation is more cause for concern, or, amongst the judiciary, if there are certain violations that may result in a revocation. I mean, I'm happy to say that there really are few violations that result in a revocation. And if they are, if they do, it's usually a new violent arrest. But for the most part, I mean, we have people that are on supervision who may have incurred, 2, 3, 4 technical violations, even some of which, when we say technical, in our world, failing to appear for court or committing a new crime during case pendency that's a supervision failure. But we have individuals who have incurred new criminal charges that remain on supervision. But I don't want to sit here and say that, we're the greatest and we're like you said, this is a peer network. We all have room to learn from one another. And I know that there are a lot of jurisdictions, and some of them that are probably on this webinar, who are doing some really great things when it comes to data. But the biggest thing is, if you're not collecting it, if you're not thinking ahead of time about the types of things that you may want to know, and I know it's hard to know what you may want to know, but if you don't have the data to start with, it is so hard to get it on the back end. I've been there. It's really hard. So at least we have it. We may not be using it right now, but there will be a future date where we will.
And absolutely right. You are totally correct, right? That it's hard to get data that you didn't already collect to try to backtrack and so, right, even if you don't know how you want to analyze it yet, right, it's a good flag, right? At least to be able to collect it, and then you can determine how best to utilize it at a later date. But right, trying to backtrack can be a tricky process. Latanya, I see you're also off mute. Would you like to share, what that's looking like for you?
I was just thinking, since we've been having these conversations, I've been thinking about what can we do with data. I'm unfortunately in the process of changing case management systems, and, we don't have a system that talks to the clerk, that, our clerk system doesn't talk to my probation system. I then have to get information from the sheriff because he runs our EM program. So, there, especially with yesterday being the 1-year anniversary of no cash bail in Illinois, there's a lot of stuff I would love to be able to see. One, what are we looking at with sanctions for, those technical violations? What's happening with that? How many are people, because they can be brought back to jail for a certain period of time based upon certain technical violations of pretrial. What is that really looking like? I don't have a database to be able to pull that. That's something I'm gonna have to be able to get from the clerk. What conditions are causing it? Are there certain offenses that's happening more than others? Are we losing people because they came in on the weekend and they can't just come in and check in with us because my courthouse is closed for them to be able to do the intake with pretrial? So it's there's the race, ethnicity, poverty differences. Are we seeing that more with technical or statutory, or so there's a lot of things. And like Michelle said, if you don't think about them all ahead of time, you don't really have it. But then a lot of times you're stuck with whatever databases or case management systems you happen to have and whether or not they're able to talk to your system partners, because different partners are collecting different types of data because they're looking at things a little differently. So then you need collaboration amongst your system partners to be willing to sit down and look at some of these things. So there's a lot of things that I hope to discuss in the future. I just don't know how successful I'll be.
Absolutely right. And like you said, it's not just your agency, it's the communication with other agencies who are also collecting data, separate data, and maybe not having, right, like this comprehensive strategy for what data we're collecting and why. And so, right, really trying to make those connections and also piece it together as needed or as relevant.
I hope there's a lot of data that AOIC or our, governing body, Administrative Office of Illinois Courts, is collecting from our various clerk systems. So I'm hoping at some point, there will be an analysis, not just the data collection, but an analysis of some of that data.
Absolutely. Yeah, really important considerations. And I know we have some questions in the chat. Shannon, want to check in with you really quickly if I know you've been keeping track of what's going on in the Q&A. So what's going on? What questions do some of our participants have for our panelists?
I'm really excited about it. There's a lot of really good ones, and some that I wouldn't even thought of, and I'm really excited to talk about them. A couple that come up are, and we can kind of put them together, is really about thinking about the structures that are happening and how much involvement judges have. So one of the questions is kind of, do your judges actually dictate how often people have to report to you? Or is that really informed by the risk assessment? Or is it your pretrial agency that determines what reporting looks like? Or is that judges? And then on the back end, how do judges respond then to non-compliance? Is it consistent? Is it one-off? They don't typically respond at all. What is kind of the general court philosophy to non-compliance? So one's on the front end of setting structures, one's on the back end of responding to non-compliance, but both about the court or judicial role there. Thoughts, LaTanya?
When we first implemented the PSA and really bolstered our pretrial services program here in Kane, there was a lot of communication with the judges as to what the reporting frequency was. We've slowly, like I said, changed that, and that's really just been at the approval of our chief judge, not the judges, the individual judges in the criminal courtrooms. So that's more internal. And like I said, we just changed it again. It was only effective, I believe, Monday, our most recent change. So they don't dictate the frequency as to how often they see us. They will, though, dictate the level of supervision that the person is placed on. It's supposed to be based upon the PSA, but we are seeing that sometimes they'll bump them up a level and things of that nature, that they would have control, but then that just means that we have determined how often and how we see them based upon that level, if that makes sense. And the second question, I think, is a good one. I don't have an answer to that. Because we have so many criminal judges, I don't know, is it consistent? Have they had discussions about, if it typically happens, what we as a judicial system, how we see that? I really don't have that answer, unfortunately.
Another interesting area to collect some data on, for sure.
Yeah. Michelle, I know that, your agency operates actually in the felony court. So is there a philosophy or approach then perhaps to non-compliance there?
Yeah, I mean, similarly to what LaTanya said, I think I told you before that we're tracking judicial responses to non-compliance, and oftentimes what we are seeing is judges aren't really responding. That's the resounding decision is no response to what we are reporting, because oftentimes what we're reporting are things like that the person is just not coming in and seeing us, or it could be that they're submitting positive drug screens and And, just in the grand scheme of things, I mean, this is in the pretrial stage, and a judge is not going to revoke a bond because somebody is testing positive for a substance in the pretrial stage. Though they may or may not, and thankfully, a lot of times we don't have special conditions that are ordered. They're not giving them pre-probation conditions that people cannot meet, especially on convicted people. And so, that oftentimes we just continue to supervise those individuals and provide whatever support that we can to them, whether it be giving them the resources that to have an assessment done or treatment or detox or whatever. But yeah, the resounding is judges, as long as people are showing up to court, right? That's like the biggest thing that's always been the conundrum of, as long as they're showing up to court, we really don't care if they're not showing up to you. Judges aren't, we dictate our policies, but they're judge approved, what the supervision requirements are, how often people are reporting. But just like LaTanya had said, judges will, especially for our electronic monitoring program, will indicate the level of supervision. In our jurisdiction, rarely are they, it's more so that they're indicating a lower level of supervision when it comes to electronic monitoring than they are deviating to a higher level of supervision. So I'm happy to say that. But just in basic pretrial supervision, traditionally they go with what the PSA assesses that person as.
Yeah, I feel like, I mean, it sounds, as I'm hearing you too, Michelle, that non-response to non-compliance isn't necessarily also a bad thing, right? Like, if what we want to see is people stay in the community, it's like a thanks so much for that information, appreciate you, we're all going to keep doing what we're doing. And I think the intention that we should expect a response, and a punitive response at that, isn't the default, right? The default can actually be just information sharing and no response at all. And I think, Michelle, your system kind of brings that up in a really refreshing way. One of the things,
I'll just add, we have an obligation to the court, and the staff, even though they may get frustrated with it, they understand that we still have an obligation to the court, and we still have an obligation to the individual who's on supervision to ensure that they are showing up to court, and as much as is possible, they're staying out of the system aside from their present case.
Absolutely. I think that's right. One of the questions then is that, I think, Michelle, maybe you had talked about this earlier, is that, you have graduated responses to noncompliance that you do internally. And as I understand you and as I hear you, you really place an emphasis on those responses internally before you go to the court and let them know what's going on. That there's really how can we handle it in-house before we need to get, mom and dad judge involved, so to speak. And so I wonder, is there a documented response grid? Are all of the ways in which you respond to the condition or the type of complaints, is that all documented and laid out for folks too?
Absolutely. And I'll point out, like, when we started to draft this graduated response matrix, I had to point out to people, these are things you were already doing. People had already been, as soon as the client didn't appear for an appointment, pick up the phone and call them. They were already doing this, or doing snail mail, sending them a letter, contacting, whatever third party contact we have. If there was a positive drug screen, you're already calling the client. I mean, a lot of the things, the administrative responses that we are taking are things that every pretrial organization has been doing. We just formalized it into a matrix. And of course, we added some other things, thinking outside of the box, things that we could do, like stepping somebody down in level of supervision, or even increasing a level of supervision if the circumstances warranted it. But for the most part, these are things that every agency is doing.
Michelle, I think one thing that you bring up that I think is so important to say explicitly is that response to noncompliance doesn't need to be punitive. That response to noncompliance can be supportive. So the idea that the response is calling more frequently, sending a text, getting into snail mail, those are still responses that are useful. In fact, the evidence suggests that those are the most effective responses, right? Elevated pretrial surveillance, actually, there's not a lot of evidence to support that elevated levels of pretrial surveillance actually increase court reporting or attendance. So responding in intensity isn't actually evidence-based at this point in time. So I think, Michelle, your point is well heard. I'm eager to hear from everyone about this. One of the other questions that somebody has is, how are your offices dealing with pretrial releases for people with disabilities? So knowing that folks that there's a disproportionate number of folks that are incarcerated with a disability, whether it be sensory disabilities like vision or hearing, intellectual disabilities, both as thinking about neurocognitive disorder more broadly from autism spectrum disorder, or even kind of dementia and Alzheimer's. When we think about aging population, psychiatric disabilities, are there new things that you're doing, and how are you navigating helping these kinds of folks? Chris, I saw you move. Is it you? Are you up? You got this one?
I was actually going to wait and listen to see what they said too, because it's an issue everywhere. I mean, you know, and we are incredibly unfortunate. We have 2 psychiatrists on our staff that will go into the jail and determine competency, but that's it. We have a psychologist as well on staff. It's part of our behavior assessment unit. So I think we're probably a little bit ahead of the curve in regards to that. But I was just in New Orleans last week, and our doctors have seen over 1,000 people so far this year. As far as dealing with them, it's incredibly hard. It's incredibly frustrating. We do a face-to-face interview on every person who comes into the jail. We have our jail office works 24 hours a day, 7 days a week. We do a face-to-face interview with that person when they come in, and we will get the jail medical involved, and the jail medical will assist us with people that have like the disabilities and things like that need extra care. We have a grant in. We are going to put an additional EMT at the jail to help the people through the process of getting placed into the jail through their preliminary arraignment. But it's incredibly hard. It's incredibly hard. In the state of Pennsylvania, we have 2 forensic hospitals, and the average wait time to get into one of those hospitals is about 80 days. So I wish I had a better answer for you, Shannon, but we're doing the best we can with what we have with the assistance of the jail.
No, I appreciate that. And the idea that you even have a psychiatrist on staff, I mean, I think those are incredible leaps forward than not being able to respond or at least assess at all. So I think it's, and I appreciate so much your vulnerability of saying, I hadn't thought of it, or like, we're doing what we can do, but we're not doing well. Like, I think it's okay that we say that. Like, you know, we're working with what we have, and really these conversations about, okay, and within that box, where can we elevate? So I appreciate that. LaTanya, thoughts from Kane?
Kind of similar to Chris. I mean, our jail has a mental health team through court services. I work for court services, but we have a diagnostic center as well. So I believe it's 5 forensic psychologists that's employed there. So they will do evaluations, fitness evaluations, things of that nature. Because we implement the PSA, and the PSA doesn't necessarily need an interview, we have a waiver right now, so we're not interviewing everyone. And for our first appearance court dates, the individual police departments are bringing them. So they're not even going through our jail necessarily. So then, if they're released on pretrial supervision, then we're working with them in the community. And it's just really knowing those community resources. You know, we've got the Association for Individual Development and some psychiatric community providers and things of that nature that we'll try to make referrals for. I know a question was about sensory. We have a contract with, it's the CARES contract. So if we have someone that needs sign language interpretation, that's for my probation officers to be able to use, and our pretrial officers, if necessary, we use that. But of course, most of the time you just deal with it when the issue comes up and try to navigate it the best way you can based upon how that individual is presenting.
Yeah, I mean, I think that makes sense. And even someone said, there's, in the chat, there might be somewhere near 50% of people who are incarcerated or coming out of jail that have some type of disability. I think what's important to remember then is that if these numbers are true, and increasingly so, depending on how we even define disability here, that it means that the expectations for what people can do might be different. And so if we're asking people to comply with a list of conditions while also navigating different disabilities, those are, again, maybe unrealistic expectations that compliance was never really on the table. And I think, I heard Chris earlier say the vast majority of people who come through Allegheny are really successful, and there's only a small people who are not. We have to think that that didn't happen by accident either, right? Like, there's something situationally different about the people who are non-compliant. And broadly speaking, they're probably navigating poverty or living in historically disinvested communities where the access to these things are not available. And so intensifying what we ask them to do is also counterproductive, because now we're asking people who have the least to do the most. And then expecting them to be perfect to that. And I think, one of these I think the conversation here is that another layer to add on here is the ways in which disability also affects that executive functioning and cognitive functioning. Chris?
Shannon, can I just interject something too?
Please.
We've had, we've been in existence since 2007, and we've had people that have come through that have been on pretrial. They will go through pretrial, get sentenced to a period of probation, and they'll come back 2 or 3 years later and say, I had to do more while I was on pretrial than I did when I was on probation. And that's not how it should be, right? You're not convicted of anything. So why are we making you do X, Y, and Z to be placed on probation for a period of 6 months, and you may see your probation officer twice?
Wow. I mean, I think that feels heavy. And I think not Chris out here naming the elephants in the room. Right. I think you bring up a really good point that we have to be thoughtful about where people are in the process, both with their resources and, what we should legally be expecting of them if they're of a pre-conviction status. So I think I think it's really important. I think one thing that it brings up for me, and I'm interested to hear from the three of you, if I name another elephant, is that then what we might be suggesting is that we might actually need to dial down pretrial. And I wonder, as directors of agencies, how does that sit for you if the reality, as you're thinking about it and really taking an equity lens, is really dialing down the monitorship and your agency's involvement might actually be the most important thing for people? LaTanya?
Well, I can say when we were getting ready for PFA implementation, we had to do all type of forms. We had to come up with new forms. And there was a lot of discussion within our jurisdiction what our court order was going to look like for our first appearance court order. Because, according to the statute, there's all different things that could be ordered, but we didn't want all those things on the order, because you put everything on the order, people just get to checking and before you know it. Because I see that. Thank you, Kevin. Yeah, I know you remember, because we were trying to look, can we only put the main little few and reduce it down, because we did not want all these conditions. I mean, I had a whole work group, okay, on what conditions, if you order, when is this going to become a financial burden on the client? Because our statute also says they can't be held if they cannot meet the release conditions. If it's a monetary issue, they can't be held just because they can't meet the monetary condition for the release. So we had a lot of thoughtful conversation with that. And so we tried to do that on the front end. And if you left it up to me, we want to do number core reminders. Really and truly, core reminders and lease checks. I want to do a core reminder to remind you have court, and I want to do a background check to notify the court if you picked up a new offense. Drug testing and evals and seeing you and making you come and calling you on the phone. I don't, but you know, I don't have that magic wand. But if it was up to me, I'll be the dentist's office. I'm reminding you of your court date, and I'm just telling the court if you picked up a new offense or you have a new warrant out there.
Listen, I feel like you said it loud enough for the people in the back, and you got some applause emojis out here from the people in the crowd. Chris or Michelle, thoughts on like what it would mean for your agencies, or the idea that dialing it down might actually be more successful for people? Michelle?
Yeah, so Shannon, you had mentioned it earlier, where in the, you know, this kind of stuck with me. I equate it to horseback riding. I hear this a lot. Get out of people's way, right? You got to step aside and let people live their lives. Provide the reminders. We all get them. We get them from our doctor's offices and our dentist's offices, and they've saved me many times with those reminders. But get out of people's way. If we put too many restrictions on people, and that is truly what causes the failure. I mean, the data shows it. We talk about technical violations, and nearly everything is a technical violation, and that's because of court-imposed conditions.
So I will piggyback on to what Michelle just said, and I applaud LaTanya because I agree with her that the majority of people who are placed onto pretrial will do incredibly well with a text reminder and leave them alone. We are looking at supervision dosage right now. The amount of times a person reports to pretrial have any impact on success rates? And someone who reports to our office once or twice is successful 81% of the time. Someone who reports to our office over 5 times is only 75% successful. You know, we were ready to do a PowerPoint in NAPSA last week, and we were able to determine through some statistics that the majority of pretrial misconduct will happen within the first 30 days. And once you get past the first 30 days, have the person report once, put them on text or on reminders, and let them go. Because after 30 days, the likelihood of a new arrest or a failure to appear goes down dramatically. So that's my 2 cents. I'm okay with knocking it down.
No, I think I think that's powerful. And I think that data also supports a lot of what we see in the post-conviction space as well, that if misconduct or if violations to non-compliance and probation spaces are going to happen, they typically happen within the first 6 months, right? You see the greatest revocation rates within the first 6 months in probation as well. So I think it makes sense that same thing is happening at a concentrated level in the pre-adjudication space. And I think, you know, LaTanya brought up that like, dialing it down might not be being absent. It could just be dialing down the ways in which we monitor people and dialing up the ways in which we support people. And so that doesn't mean that pretrial agencies are irrelevant. I think they're incredibly useful and really needed. And it's about rethinking what it is that we're doing and the job to be done more broadly, I think. With that, I think those are a lot of the questions I see in the Q&A and in the chat.
We just got a new one.
Yeah. Yep. The last one here is just that for the folks here, are people that are required to report more often, usually quote a higher risk, and which would say that, or they were less likely to comply in the first place.
So our reporting is based on risk level. So yes, it's based on risk level, but we will drop those people down relatively quickly based on compliance.
Same here.
And just to kind of go to the risk issue, after we implemented the PSA, we had Harvard come out and do a validation study of our PSA implementation a few years back. And even those that scored the very highest, scored a 6.6, they were still, according to our data, 75% likely to be arrest-free and 57% likely to appear. So did your appearance rates go down? Yeah, but you got more than a 50% chance that person is going to appear in court, and you got 3/4 of a chance that they're not going to pick up any new offenses. So really, are us seeing them playing a huge factor in that? I don't know. That's a question.
I think LaTanya, that's right. I mean, I think that's true. When we spend a lot of time at JSP doing validations, and that's pretty consistent with what we see, that even folks that are measured into high risk categories on the PSA or the VPRE or other iterations, there's like still something like 50 to 60% of people in high risk that are successful. So we have to really challenge ourselves to like take a step back from the term high risk and really challenge ourselves of like, what does that really mean? The last question as we approach the bottom of the hour from someone is, how do you respond to concerns? Oh, this is a hard one, I think. How do you respond to concerns about fewer restrictions for folks with more serious charges? In my county, 91% of people are released to the community, and the individuals who come to our office are typically placed on GPS for cases like stalking, domestic violence. Do you still support having fewer conditions in those cases? LaTanya, I know you do a lot of work there, so.
I mean, the majority of our cases, I think when we were looking at our data, and Kevin can probably correct me if I'm wrong, when we were looking at our data to prepare for PSA, I think we were at about 75% or more of our offenses that we were expecting to come through first appearance course were going to be DVs. So we took a look at that. So is there a certain population that needs some conditions such as GPS monitoring to be able to keep the community safe? Absolutely. So I don't want to broad brush stroke what I said earlier. But I think it should be really based upon what is going on. You know what I mean? Is this a domestic violence case? Is it the first one? What was the level of harm? You know, what factors can be put in place to protect the victim? What can you do with no contact orders? And I will say, when Kimberly asked the question about pretrial conditions, our DV cases get more pretrial conditions than anybody, than our gun cases, than anybody else. Because you got your stay away orders, you got to turn in your FOIA card, you got to turn in your guns, you got to pick up your things, and I think that's how it should be, in all honesty. And if we're really having a frank conversation as to what was happening in Illinois before pretrial, the PFA, they were just being recogged or paying $200, $300 to get out, and not necessarily having as much supervision or conditions because, you know, they were a Class A misdemeanor, or, you know, you see what I'm saying? So I think it has to be thoughtful what you're doing, and we got to get away from just coming up with conditions to feel better, because they still are not convicted.
Ooh, LaTanya with the mic drop at the end. I feel like that's right. I think we have to remind ourselves that no contact orders, turning in FOIA, turning in guns, all of those things are important. And I don't think here we're suggesting otherwise. And there are a list of conditions that the evidence doesn't suggest that they help us do the job to be done, which is get people to court. So I think you're right that we have to really challenge ourselves to let go of the things that are not really going to help people get to the finish line, which is ultimately getting to court and having their case disposed in whatever way, right, without tying up the court. With that, I appreciate all of the insights. So that I'm going to turn back to Kimberly.
All right, thank you all so much, LaTanya, Chris, Michelle. Thank you so much for your expertise, for your willingness to share it in this space and really flesh out this conversation, right? There are so many things that you all are doing in your counties that are equitably supporting people through pretrial, and also acknowledging, right, that everybody has somewhere where we can delve a little bit more deeply into how do we continue this equitable approach? How do we continue this equity lens in this regard? So really appreciative of all of your experience and your willingness to share in this space and everybody's participation here today. And so as we are closing out, just want to let you all know we will be sending a follow-up email after today's webinar. We have a survey link for you. We are hoping that you will take it. We always want to hear your feedback, right? What is resonating with you? What do you want to see more of? And what are you suggesting for the Pet Network to do the next time? So please take some time to just give us some feedback. We really do appreciate it. And all of the webinars we've been doing, the content that we've been covering have been stemming from a lot of the things that people have said in their survey responses that they want to learn more about. So we really do take your feedback seriously and appreciate it. In addition to the survey link, we will include an equity and non-compliance reporting handout that really goes into more detail about what we're discussing today. Additionally, we will share our equity in action tool, really a toolkit to think about how to incorporate equity more broadly in the pretrial space, not just in reporting, but just generally how to increase that. And we also have some evaluating the evidence handouts. Our team member, Jay Rochelle, she did post some of that in the chat, but we will send it out again in our follow-up email, as well as the link to the recording from today's webinar. But again, just want to thank you all so much for joining us. If you have any questions about PET, please feel free to email me. I'm going to put my email in the chat. But other than that, thank you all, and I hope you enjoy the rest of your day. And thank you to our panelists another time. Thanks, everyone.